Good day. I'm Liesl Pretorius, legal advisor with Freedom of Religion South Africa, or 4SA for short. For this week's weekly discussion on important issues affecting religious freedom, I'll be talking to my colleague, Daniela Ellerbeck, also a legal advisor with Freedom of Religion South Africa. And what we'll be discussing is a significant case, a judgment recently handed down by SCOTUS. Now, SCOTUS is an acronym. It stands for the Supreme Court of the of Appeal of the United States of America. And the reason why we'll be discussing this case, because it has a significant impact on freedom of religion, specifically freedom of religious expression. So the case of 303 Creative LCC versus Elenis concerns a website designer. Her name is Laurie Smith. And Mrs. Smith, she works for herself, she designs websites, and she sought legal clarity about whether the law in Colorado, which is the state where she stays, whether she would be protected, specifically her right to decline work, because she's a creative person and she creates websites. She doesn't want to create websites of which the message that she creates is against her religious beliefs and values, and she wanted to make sure that the law of Colorado protects her. And so it is definitely a very interesting case and a real life example of where freedom of religion, especially in the commercial world, the freedom of religion of a religious expression and protecting your beliefs becomes very, very real. And how it practically plays out. So, Daniela, I briefly mentioned the case, but can you please give us a little background? What are the facts of this case? What is it about?
So, Liesl, this case centers around Miss Laurie Smith. As you said, she's a website designer and she works for herself. She owns her own business. And Laurie has always provided her services to everyone. So all customers, irrespective of that customer's race, their beliefs, their sex, their sexual orientation, whatever. What she has never done for anyone was accept work that would require her to produce something that goes against her own views or beliefs. So for her, what mattered was not the customer's identity, but the message that the customer was asking her to produce. Thus, for example, she never accepted work from anyone that would require her to produce anything that encourages violence or degrades people or that goes against her own personal beliefs. For example, by promoting another religion or a worldview such as atheism. So it's important to understand that what she had a problem with was not the people. She gladly made custom websites for anyone, but the possibility of being forced to produce work that conveys a message that she doesn't believe or support, irrespective of who asked for it. Now, Laurie wanted to grow her business by starting to design wedding websites for couples. And the idea being that these wedding websites would be very much curated, individualized, and tailored. So they would include text, graphic arts, and videos that share and celebrate the details of that particular couple's love story. So it would be a very unique website centered around the very unique couple and their story. But before she expanded her business, she wanted to be sure that Colorado, the state where she lives, would not force her to accept jobs that go against her own views and beliefs. And this is why she approached the courts to get legal clarity.
So, legally speaking, what is the crux of this matter? Because what I'm hearing is that because it's for her, it's about the message. It's not about the people, and she's a creative person. So obviously, this is about her. Her message is her expression. It is her speech. So legally speaking, what is the crux of that? What does it boil down to?
This case involves a variety of rights.
Because I think that's important because there are various rights. Similar rights in the US to South Africa. There are differences. We'll come to that, but it's important when we are in the public to realize, how do we balance these rights against each other? What are the limits of these rights that we have, and to ensure that there's a maximum protection of fundamental rights. Now, as you mentioned, this is an American case. We're here in South Africa. So American free speech law and freedom of religion laws obviously will look a bit differently from our laws, but I think there are enough similarities. But how is freedom of expression and freedom of religion protected in America specifically? You mentioned the First Amendment, for example.
So the American Constitution is obviously quite a few hundred years older than South Africa's Constitution. And in my personal opinion, our Constitution, therefore, has had hundreds of years of benefit of other countries wrestling out how to write about rights and what these rights entail and things like that. So our Constitution's Bill of Rights is very neat. You know, you've got the right to dignity, the right to equality, the right to life, you know, religious freedom, freedom of expression, all listed individually as, you know, like say in section 16 and section 15 and section 9. So very clear, very neat. Now, the American Constitution is not as neat, but it's one of the first instruments trying to, in a constitutional way, protect all of these things. So what the American Constitution has, for example, is a number of amendments. Now, I think for most South Africans, you'll probably be aware of like law and order and pleading the fifth and things like that. That's our experience with the American Constitution and amendments. But the First Amendment of the American Constitution does a number of things simultaneously. So firstly, it says that the government, the state, can't endorse any religion. And this is known as the Establishment Clause, and it requires separation between the church and the state, demanding that America's government be religiously neutral. In other words, it can't endorse a specific religion. It can't show favoritism amongst religions and, you know, by siding itself with a particular religion. It needs to be neutral. And secondly, the First Amendment says that religious freedom is protected, and this is known as the Free Exercise Clause, and it protects the ability to hold religious beliefs of all kinds, not just in your heart, but then to publicly live those beliefs out in daily life. And thirdly, it also says that freedom of expression is protected, and this is known as the Free Speech Clause, and it protects expression, which is wider than just speech and includes expressive acts such as designing a website. Now, the US Supreme Court, SCOTUS, as you said, which is America's highest court, has also confirmed in a number of cases that these freedoms and their protection must be understood as serving a complementary purpose. So these clauses, all found in the same amendment, are not at war with one another, and one is not more important than the other. They're complementary and they're not conflicting. Now, the issue came in because of the Colorado Anti-Discrimination Act, CARDA, as we've said, which prohibits businesses from discriminating on the basis of, for example, race, beliefs, disability, sexual orientation, and so forth. And a business can be found guilty of refusing to provide a customer with goods or services on these grounds. And this is what Ms. Smith was trying to avoid. When she thought about getting into the wedding website market, she was like, personally, I believe marriage is between a man and a woman. I know this is a very unpopular view, but if I'm going to expand my business to do wedding websites, I don't want to be forced to do websites that have a message that go against my personal beliefs. So will CARDA, will the state force me? Will they see this as discrimination in American law, South African law, unfair discrimination based on, for example, sexual orientation? If I say I only want to do wedding websites for, you know, the conservative view of marriage being between a heterosexual couple.
Yeah, it's quite considerate actually, for a person to go to the length to beforehand to actually know what the law says. And the American Constitution, with all its amendments, it has very robust protection of freedom of speech and freedom of religion. And I think that is very important. And it's also important to note how these laws, or how these amendments, these protection of rights, how they're not at war with each other, as you said. They're not in competition. I think sometimes people have, you know, when you have seemingly competing rights, people think, you know, it's like a competition, but the ideal approach should be, let's maximize freedoms. They complement each other, they enforce each other, they support each other. I think that's the right kind of democratic constitutional approach if you value rights and freedoms.
No, exactly. And that's very similar to what South Africa's Constitutional Court has said, is that when rights appear to be in conflict with one another, they need to be harmonized with one another. The public square is a diverse place and needs to be able to cater for diverse expressions, diverse opinions. Tolerance is a constitutional virtue. So that means the fact that you'll face views that you dislike, disagree with, find hurtful, offensive, and you need to be okay with that. And you need to make room for one another. So,
exactly.
I mean,
space for views that don't agree with your own in the public square, and you need to be respectful of it.
Exactly. And I mean, what happened in Miss Laurie's case is very much in South Africa what we would deem a declarator order, which is going to court saying, declare what the rights are and how they should be balanced in the specific instance. So before she, for example, fell foul of the law, she wanted to know, okay, exactly what does the law have to say about this? So yeah, it was definitely an approach that one could argue is considerate, because she didn't want to break the law and she didn't want to get in trouble with the law, and she also didn't want to start something that a side of her business that would, put her at odds with the state that she's in, and she just wanted to know where she stood.
And now that this judgment has been handed down by America's highest court, it also provides a lot of clarity and guidance for other people who might have been uncertain. So, Daniela, the delivery of this, like you say, she has a website design service. And we've touched on it, freedom of expression, freedom of religion. How is the design of a website a religious freedom and a religious expression, a freedom of expression, and specifically a religious expression issue?
Because creative work is speech. And the court said that Laurie's design services express and communicate ideas, and so they're a form of expression. And Laurie doesn't lose her First Amendment's free speech protection because she sells her expression. So because she sells her creative work, she offers her creative work or expression for sale. And the court said just because she sells it doesn't mean she loses her right to freedom of expression. Ms. Smith's, Laurie's design services are still protected by America's free speech clause. And SCOTUS also confirmed that to the extent that Colorado's equality laws could compel and even punish someone who sells speech, like Laurie and other artists, for example, to accept all work, no matter the topic or message of the expression they're asked to create. The court confirmed that this is an unacceptable limitation of their free speech, of an artist's free speech. And it may not be allowed. And the bottom line is that Colorado can't use its Anti-Discrimination Act to deny Laurie the right to decide what she says or not, what the content of her messages is. On a very interesting side note, the court also mentioned and looked how equality laws can expand over time, and that they get too big and too wide when they start forcing speech.
That's actually anti-equality and anti-freedom. It undermines the very purpose that people originally set out when they
Equal rights in the
designed
public
such
space,
laws.
yeah.
So you have to be very careful that you don't undermine yourself. I think this is a significant case. It's at least it shows very importantly that you don't check your rights and your freedoms when you leave your front door. But even though even though it is an American judgment, what is the significance of this judgment in South Africa? I mean, because we also have anti-discrimination laws and we've got a hate speech law in the pipeline.
Yeah, I like what you just said, Liesl, before I answer your question about you might end up undermining yourself, because that's something that happens when you say, look, I can force speech out of your mouth. Speech that you disagree with, I can force you to say. I can force you to do things that you disagree with. Because essentially what you've undermined is you've undermined freedom of expression, which means that that right is weaker, which means that your right to freedom of expression is weaker, and someone else can force you to say things that you don't like. And that is why tolerance and diversity in the public space and maximizing freedom is important, because that actually protects everyone. Doesn't make everyone happy in every situation, but it's the safest thing to do in a diverse society. Turning to your question about what the significance of, this SCOTUS, this American judgment has for South Africa, like you said, we have laws against unfair discrimination, what Americans would call anti-discrimination laws. And we're even looking at the hate speech bill being in front of the second House of Parliament and, the last step before it goes to the president to be signed into law. So the first thing to note about SCOTUS's judgment in Laurie's case is that this is foreign law. This comes from an American court. It's not binding on all South African courts. But foreign cases have persuasive value, so courts can look at them, because it's interesting to see how other countries and other courts and legal systems solve similar problems, because maybe we can learn something from them. They're not binding on us. We don't have to do what they did, but they can be persuasive. And this case is interesting and important, both from a comparative law point of view, so comparing how the Americans solved this problem of diverse views in the public space and forced speech, for example, but also from identifying international trends in the area of religious freedom law, which inevitably spills over into our local context. And they're not particularly interested in this case. There are similarities between Colorado's Anti-Discrimination Act, CARDA, and South Africa's Promotion of Equality and Prevention of Unfair Discrimination Act of 2000, commonly known as either PEWDA or the Equality Act. So in this light, the case's emphasis that the right to freedom of expression belongs to everyone, not just those that the government happens to find desirable or worthy is very insightful. Now, we will at some point or another, all of us will come across ideas that we don't like, that we find offensive, and that we even find hurtful. And this is when the importance of protecting free speech becomes very real and practical. And the solution is not to shut people down and dictate to them what to say, i.e. to force speech out of their mouth. The solution is tolerance, true tolerance, which makes space for opposing and different views. Because as we've said, the moment you say that the right to freedom of expression doesn't actually mean that you can't be forced to say something you disagree with, you undermine your own right to freedom of expression, and someone else can force you to say stuff that you don't disagree with. And the South African Constitution envisages a rich and complex pluralistic society where diversity is celebrated and not just tolerated, and where everyone is free to think and speak as they wish, not as the state demands. Because remember, our history again is one of coming out of state censorship and apartheid. So freedom of expression in our country, our constitutional court, our highest court has said is no less important here than it is in America.
Yes, absolutely. I'm reminded of a quote I read somewhere about, a clever person learns from their mistake, but a wise person can learn from somebody else's mistakes. And this case was, this judgment wasn't a mistake. It was a win for freedom. And some people might not agree that Mrs. Smith wouldn't render her services or make herself available to convey certain messages. But it's actually a win for the freedom of such people, of even the person who might not agree with her. Because if that person was in a business and they didn't want to, create a message or say something that was against their beliefs, they would also be protected. And that's, like, you've touched on that, how if I undermine anybody's equality right or right to say things just because I don't agree with it, my freedom of expression and my freedom to believe what I want to believe or not to believe anything at all is also undermined. So it really is like, look out for yourself and look out for those around you. And especially the lessons of our country, where we've come from with state censorship and one ideology kind of being forced on people. That's not something we want to return to. We have hard-won freedoms, and we want to continue down the track of a society based on equality and human dignity and rights and freedoms that respects this diversity that we have, which is great. Thank you for the discussion, Daniela. I think it was very enlightening to hear about this case.
Good day. This is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.